students and everyone present here. I, on behalf of the West Bengal National University of Juridical Sciences, would like to extend a very warm welcome to the 7th M.K. Nambyar Memorial Lecture to be delivered by Honorable Justice Rohinton Nariman and to be presided over by Professor V. Vijay Kumar, former Vice Chancellor, NNIU, Bhopal. This year, the topic of discussion is the role of the governor of a state, watchdog of the center, or a meaningful head of state. Now I would like to invite Professor Dr. Shamik Singh, Faculty Advisor to the Constitutional Law Society, to say a few words.
Thank you, Orchita. Honorable Mr. Justice Rohinton Nariman, Professor Vijay Kumar, Vice Chancellor Sir, Registrar Sir, my colleagues, students. The M.K. Nambyar lecture is an auspicious occasion in the calendar of NUJS, the academic calendar of NUJS. It is one of those pioneering flagship lectures on constitutional law, and this is the 7th edition of the M.K. Nambyar lecture. The previous lectures have been delivered by luminaries. The very first M.K. Nambyar Memorial Lecture was delivered by Honorable Judge Michael Kirby from Australia. The second lecture was delivered by Professor Mark Gallanter. The third one was by Professor Martha Nussbaum. The fourth Nambyar Memorial Lecture was delivered by former Chief Justice of Bhutan, Mr. Justice Sonam Togge. The fifth by Professor Catherine Mackinnon. And the sixth one, the last one in 2019, was delivered by Honorable Mr. Justice Dhananjay Chandrachud. So after a gap of 6 years, we are back hosting the M.K. Nambyar Memorial Lecture. And this is an auspicious occasion, like I have said. We have amidst us Mr. Justice Rohinton Nariman, of course, who needs no introduction before us. His erudition, his judgments speak for themselves, and we are all waiting very keenly to listen to him on a topic of immense contemporary relevance. But before we proceed to the main lecture, here is something I want to read out for you. As you understand, this M.K. Nambyar Memorial Lecture was instituted by Mr. K.K. Venugopal, former Attorney General of India, in the memory of his late father, Mr. M.K. Nambyar, who was again a legend of constitutional litigation in India. So, Mr. Venugopal, who's 92 and not keeping too well, he could not travel down to Kolkata, but as always, he has sent his blessings, and he has sent this letter which he would wish that this letter be read out. So, Mr. Venugopal writes, and I quote, "I thank the West Bengal National University of Juridical Sciences for organizing the 7th M.K. Nambyar Memorial Lecture in honor of my father, the late Shri M.K. Nambyar. I am delighted that no less than Justice Rohinton Nariman has agreed to deliver the lecture this year. He is not only an eminent judge, jurist and legal philosopher, but also an accomplished religious scholar. His contributions include many seminal judicial pronouncements, as well as multiple books and talks on a diverse range of subjects. Many of you may not know that he was ordained as a priest at the tender age of 12 years. The subject of today's lecture is both important and topical, relating to the role of the governor under our constitution. We are extremely fortunate to have Justice Nariman, a constitutional czar par excellence, to share these views. I have no doubt that he will leave the audience enriched and enlightened." Unquote. K.K. Venugopal. So with these words, we open the floor for the M.K. Nambyar Memorial Lecture. In the beginning, we'll have some formalities, and after that, we will proceed to the main lecture. Thank you so much.
After the introduction of Justice Nariman by Mr. Honorable K.K. Venugopal, I don't think we need a separate introduction. However, we have to do this formality. So we are honored to have Justice R.F. Nariman, former Judge, Supreme Court of India, here with us. He has been a senior counsel at the Supreme Court and a Solicitor General of India. as John Singh, Joseph Shine, and many others that you know. He has authored several wonderful books, such as Discordant Notes, The Voice of the Dissent in the Last Court of Resort, The Basic Structure Doctrine, Protector of Constitutional Integrity, among others. So we are honored that he will be delivering the lecture of M.K. Nambyar. And we also have Professor Vijay Kumar, former Vice Chancellor NLIU, with us. He has held several other positions before becoming a Vice Chancellor at NLIU Bhopal. He has been a professor and registrar at NLSIU Bangalore. He has also been a Vice Chancellor at the Dr. Ambedkar Law University, Chennai. He specializes in constitutional law, human rights, and other specializations. He is a visiting scholar at York University, Toronto, Canada. And he has been awarded the Best Vice Chancellor Award by the Indian Red Cross Society. We are honored to have you, sir. Now we would like to proceed with the felicitation. I would like to invite our Honorable Vice Chancellor, sir, to kindly felicitate Justice Nariman. I would like to call Namrata to bring the felicitations. We are extremely honored, sir. Thank you, Namrata and Saupardika. I would now like to request our Honorable Registrar, sir, to kindly felicitate Professor Vijay Kumar. And I would request Namrata and Saupardika to again bring the flowers and the mementos. Thank you.
Practices abroad, the constitutional conventions elsewhere, right? And also the history from 1950, what has happened. In law school, Bangalore, I'm one among the founding members of the law school, which we started in a small caste, 3 castes in the Bangalore University. And then we always had minimum 3 teachers in constitutional law, sometimes 7, including the former Chief Justice, Justice Venkatraman, who was holding the office as a professor, chair professor. Sometimes Dr. Menon would join. So sometimes 7 to 8 teachers, Professor Ajappa. Now the same text we see, but each and every presenter will make his or her view based on their experiences, their understanding. And everyone respectfully would disagree or partially agree, giving some reasons. We used to fight with respect. We respected the views of everyone. And this sort of learning made the students little better. I would like to recall an anecdote here, sir, with your permission. Justice B.R. Krishnaya used to visit the law school after his retirement and used to come and teach criminal law. And one year, I don't know what happened, he said he would like to get into constitutional law class. And in the constitutional law class, in those days, we don't, like what you have today, ChatGPT, right? The other, maybe the laptop was slowly coming in, but we used to give a set of reading material, photocopied, and every student is expected to go through. And we have given a judgment delivered by the Supreme Court, a 7-judge bench, in Samsher Singh versus State of Punjab, 1974 Supreme Court. where Justice Iyer wrote a separate judgment but concurring judgment for himself and for Justice Bhagwati. That was given, and if I had seen the reading material of each and every student, I am not talking about one student, each and every student, the student would have highlighted some portions, underlined something in different colors, because we have gone through the text a number of times. So when you wanted to come to constitutional law class, we just finished that presentation of the case. And then I cautioned him, sir, this class is a very vociferous class. They will ask questions which you may not appreciate. He said, which year do they belong to? I said, it's second year students. Oh, second year students, it's all that I'll manage. I said, okay, fine. So I took him to the class, very briefly introduced him to the class, and he started teaching. 20 minutes, there was not even a single hand raised. He turned, looked at me and said, Professor Vijay Kumar, he said that this class is vociferous, nobody is asking any question. It's always 2 hours class, no 2 consecutive hours. And as he was telling me, one student raised his hand. The remaining an hour and 40 minutes, he was bombarded with all the questions, the judgment in everyone's hand, the text of the Constitution in everyone's hand. When the Constitution says this, how can you come to this conclusion? Right? If everything is based on the British Constitution, why did we write the Constitution? If you think that the office of the President and the Governor is nothing but rubber stamp, why did you contest the election in the presidential election later after retirement? All types of questions. Because the students had the free mind to question, right? The expert, whoever is coming in, and there is a culture we created. And then we came across an interesting book. And the author comes from Calcutta. I would appreciate every student goes through this book at least once. I would have purchased more than 100 copies from University of Bombay, and nowadays the books are not available. It was only 15 rupees, priced for 15 rupees. It was a Settlewood Memorial Lecture delivered in November 1966, which was printed by the University of Bombay, and the book was titled The Critical Problems of the Indian Constitution. And this judgment, this lecture was delivered by Justice P.B. Mukherjee. Justice P.B. Mukherjee, whose elder brother became the Chief Justice of India, and I think he was the only judge who died when he was in office. If you read the book, I can guarantee you, right? If you don't get the book, please let me know. I have put it on the soft form I have. I will forward it to the Vice Chancellor. I think everyone should read this at least once in your lifetime, though not now. And if you try to understand constitutional law only for examination, I think you are committing a huge blunder. Right? Today I can with some amount of confidence tell you, if you are an expert in constitutional law and public international law, I think you can practice anywhere in the world, any branch of law. Right? So these two, I think I would request all the students with folded hands, please read this book. You will understand, as the title goes, the critical problems of the Indian Constitution. It opens up your mind. Not that everything he said was right. We also critique that. Not everything he said was right. But I think it opens your mind to think the other way around. I think that is the beauty, right, of this particular book. Not a very lengthy book. It's around 195 pages. If you remove the cover pages, maybe around 190 pages. Very beautifully written on wonderful themes. There are about 6-7 chapters. Every chapter is worth reading, right? And if you read that, I think your way of understanding will certainly change to a great extent. You will find responses even before the Supreme Court says something. We can also come to conclusion as citizens of this country how this constitution is to be looked at, right? We are all part of the preamble, we the people of India, so we also have a right to say what is right. And therefore, this is one book. The second book which you have to read is by Bharatiya Vidya Bhavan. It's around 55-page book written by Dr. K.M. Munshi. Dr. K.M. Munshi was one among the members of the Constituent Assembly, and in 1966 he published a book, this small booklet, 54 pages. If you sit tight, it will not take more than an hour for you to read. Right? From the arguments that he presented during the Constituent Assembly debates, that India is a parliamentary form of government, so on and so forth, to something president under the Indian Constitution. And finally, he comes to a conclusion I would like to read. When I say president, it also includes the office of the governor, right, who is the executive of the states, right? Dr. Munshi, an elected president, therefore, could never enjoy any authority and status worth the name if he, by practice or convention, gives up or is made to give up the powers and functions expressly vested in him by the Constitution. Right? What transpired during this period of 16 years, God only knows. Right? Who was vehemently arguing in favor of the parliamentary form of government based on the British, Constitution, and this is what he had to say. So there are a lot many things like this which we need to read, and I would like to take 2 more minutes to raise some interesting questions to the students. Right? If you carefully read Article 74 and Article 53, let me just, the same thing is reflected in these states, also for the governor and the Council of Ministers. There shall be a Council of Ministers with the Chief Minister in the states or the Prime Minister in the center, who shall aid and advise. Ladies and gentlemen, I would like to just underline this, aid and advise. What is the meaning of this phrase, aid and advice, has not received attention by the scholars in India or by the students in this country. Right? And it also uses in the discharge of the functions. The phrase used is functions. I want you to carefully look into the provisions of the Constitution, whereas Article 53 and similarly for the governor, the executive power is vested, right? But unfortunately what is vested has been divested by practices, and I think the process of election of the governor, the president, the nomination of a, I think we have a good constitution, but we are successful in making it fail, right? By choosing people who should not be there as governors, right? The practices, maybe retired politicians or defeated politicians, all these things we have discussed. So therefore, whether the practices should prevail over the text of the Constitution or whether the Constitution has to prevail, right? I think that's a huge question which I will leave it at this point of time. Maybe after the presentation by Justice Nariman, I'll get back on some other aspects. Thank you very much.
Thank you so much, Professor Vijay Kumar, for sharing your experiences. I would now like to request Justice Nariman to deliver the 7th MK Nambyar Memorial Lecture.
Vice Chancellor Chakravarti, Professor Vijay Kumar, fellow students, ladies and gentlemen. When India became a sovereign democratic republic, the first thing that we did was to shake off the British crown, which was a hereditary monarchy. And instead of a hereditary monarch as head of state, we had an elected president as head of state. One would have thought that the governor as head of state of one of the states which comprise India would also follow suit and be a microcosm of exactly what the president is at the center. But it was not to be. Interestingly, the president as head of state is a very, very carefully guarded person. First and foremost, under our constitution, as you just heard, he is the embodiment of the executive power. He is also the commander-in-chief of all the forces. This is also interesting under Article 53. Under Article 54, the founding fathers went out of their way to see that not only did an indirect election take place through the members of parliament, because as you know, the Lok Sabha is the representative of the people as a whole, and the Rajya Sabha consists of representatives from the states. But it went on to have an electoral college not only of the Lok Sabha and Rajya Sabha, but also of all the elected MLAs of the states. Now this is interesting. And finally, in Article 55, the founding fathers also saw to it that roughly half the votes cast for the president each time would belong to Parliament as a body and roughly half to the collective MLAs of all these states. Of course, today we have 28 states. At that time, we had a much lesser number. And a mathematical formula is given in Article 55 as to how this is to be achieved. Under Article 56, the term of office of the president is 5 years. And importantly, he can only be removed from office by way of impeachment, which is an extremely difficult process. And impeachment for what? For violating any provision of the Constitution. His oath, in fact, under Article 60, makes it clear that he has to abide by the Constitution and that he would seek to see that the welfare of the people as a whole is adhered to. Now, with these provisions for the president, why was there something different for the governors? In fact, it was so different that the difference becomes stark when I now compare Articles 52 onwards with Articles 153 onwards, which otherwise parallel what happens so far as governors as heads of state are concerned. Under 153, there shall be governors of states. There can be more than one or more states of which there can be governors, and vice versa. And extremely importantly, the point of departure comes with Article 154, 155 and 156. Because the governor now is appointed by the president. No election. There was an article, I think 131, draft article in the Constitution, which mooted elections for governors. But somehow or the other was shelved because the founding fathers felt at that point of time that there might be a clash between an elected governor and an elected prime minister on the other end. So, appointment became the mode. And then under 156, we have a very strange provision. We are told that the governor is appointed at the pleasure of the president, which means hire and fire. It actually means that the president can pick up a person as governor today and fire him tomorrow without bond, even though ordinarily his term is stated to be for 5 years. And this is despite the fact that his oath, that is the governor's oath, actually parallels that of the president. And this is very, very important to remember. Because equally is the governor to preserve, protect, defend the Constitution, just like the president and the laws. And most importantly, to serve the people of the state of which he is governed. And yet, the appointment process is not at all even remotely in the hands of either the people of the state or the elected members of the state. It is entirely with the center. Given this fundamental dichotomy and given the fact that he could be fired and that this state of affairs continued for 60 years. We had a constitution bench judgment in Shingal's case in 2010, which at least remedied the firing part. PILs were filed before the Supreme Court because governors of 4 states had been summarily removed by the center. Even though the matter had become academic or moot, so to speak. Fortunately, in view of the importance of the questions involved, the Constitution bench took up the matter. And when it took up the matter, it delved into the doctrine of pleasure as we know it in our Constitution in great detail. It first spoke of persons who were appointed not by the doctrine of pleasure at all, but purely by the Constitution and removable again, only by the Constitution. If you remember, I had told you that the President was elected and could only be impeached. Impeachment became so difficult because under Article 61, first, one of the 2 houses of Parliament would have to prefer a charge against the President. That would have to be done by a minimum of 25% of the entire strength of the House, not members present and voting, mind you, entire strength. 14 days notice was given to him. And then the charge preferred had actually to be carried by 2/3 of the entirety of that House, whichever is it, Lok Sabha or Rajya Sabha. Finally, the other House would then investigate the charge. And if again by a 2/3 majority of the entire strength of that House found that the charge was preferred, the President was impeached and had to be removed. This is again in stark contrast with what would happen to, let us say, Supreme Court judges. Under Article 124(4), a Supreme Court judge can also be removed only by impeachment. But the process is very different. There, so long as you have a majority of 2/3 of those present and voting in a House which at least has half its strength, the judge gets impeached. So, with the head of state, great care was taken to see that he could not possibly be removed improperly in any manner, and that he could only be removed by this 2/3 complete majority, and that too for violating the Constitution. When it came to a governor, however, I told you he could be fired overnight, and it could be without reason. It could possibly be because he's out of sync with the centre's policies. It could be that the centre had lost confidence in him. All this was righted finally only in 2010. And in 2010, the judgment of the Supreme Court in Shingal's case contrasted the President and others like Supreme Court judges who were removable only by impeachment with those who were under the pleasure of the appointing authority. Now, the pleasure of the appointing authority also was conditioned sometimes. For example, if you were a civil servant, you couldn't just be fired. You had to go through the drill of Article 311, which meant that the civil servant had to be properly charged, there had to be an inquiry, and post-inquiry, if he was found guilty, only then was he liable to be dismissed or removed or reduced in rank. In contrast to this, you had a complete doctrine of pleasure where confidence alone was the important thing that was to be considered. And here you had the Advocate General of the state, for example. Or you had ministers. If a minister also had lost confidence of the government of the state, he could be fired immediately. Now, was there an intermediate situation so far as governors were concerned? The court laid down that there was for the first time. And they said, though he is appointed at the pleasure of the President, given the fact that he has 2 functions, as was pointed out to you. First, that he is head of state. with an oath to abide by the constitution and look after the welfare of the people of the state. And second, to be a vital link between centre and state. It was clearly laid down that if you are just out of sync with the centre, its policies, or the centre had lost confidence in you, these would not be grounds that would avail for removing a governor, because it would be antithetical to his oath and antithetical to removing a head of state without any cause. So if challenged, there had to be just cause. So judicial review therefore became important, and a removal was judicially reviewable on the ground that the governor concerned had been removed either arbitrarily or malafide. And it was then laid down as a matter of law that all such removals, when tested, must have very good reason, which is shown to the court. It need not be shown to the governor concerned, but ultimately which is shown to the court. Good and compelling reasons is what the judgment of the Supreme Court actually said. So in 2010 at least, one of the two prongs, not the appointment prong but the removal prong at least, was safeguarded by constitutional means. What exactly, therefore, is the role of a governor? And this is the question that we must pose given the topic today. Now, very early in our constitutional history, our first president, Dr. Rajendra Prasad, actually referred the Hindu Code Bill, which was given to him, to M.C. Setalvad, who was then the learned Attorney General for India, and asked whether he was a mere rubber stamp or whether he could substantively go into each provision and make changes, not just suggestive, but changes which Pandit Nehru would have to accept. Pandit Nehru, being the gentleman he was, referred the matter to the Attorney General. And Setalvad's opinion was absolutely unequivocal. There's no question of the president being a parallel source of power, even though he's elected, mind you. The president then went and asked Sir Adlani Krishnaswamy Iyer, who was also one of the great stalwarts of the Constituent Assembly. Sir Adlani's opinion was even more extreme than that of Motilal Setalvad. He said every single function that the president performs under the Constitution, even if it is giving a special address to Parliament or giving a message to Parliament, is conditioned by previous approval from the cabinet. And armed with these two opinions, therefore, case law by and large adhered to this until, again, there was a drift. And the drift came to a head in Sardari Lal's case in 1971. Sardari Lal was a constitution bench of 5 judges who had to decide on this very question. And on the facts in Sardari Lal, Article 311(2)(c), that proviso C, came up for examination, which proviso said that if the president is satisfied that no inquiry is required to remove a civil servant because of reasons of security of state, such person can be removed without inquiry. Now the question was it the president's satisfaction personal, or was it the satisfaction of the central cabinet? The Supreme Court, in a bench of 5, said no. Given the fact that it was security of state, it would be personally that of the president. And this was a major departure from what had been going on since the time of the opinions of Setalvad and Adlani. Sardari Lal's judgment, therefore, was open to doubt. And then came to be questioned in the judgment that was spoken about before just now, Shamsher Singh, which judgment was a judgment of 7 learned judges of the Supreme Court. Now, even though the main judgment was written by Chief Justice Ray, speaking for himself and for other learned judges, the judgment always quoted is the concurring judgment of Justice Krishna, speaking for himself, and Justice Bhagwat. And why it is quoted is probably because of the language used first, which I shall advert to immediately, and the substance of what was stated in that concurring judgment. First, the language. Justice Krishna begins by saying that there was a large shopping list of constitutions before the founding fathers. And even though that shopping list was large, the founding fathers ultimately confined it only to the constitutions of Commonwealth countries. He then went on to pose the critical question thus. He said, are the Raj Bhavans and or Rashtrapati Bhavan an Indian Buckingham Palace, or are they a midway house between the Buckingham Palace and the White House in the United States? He then also went on picturesquely to add, is the President a faint light in the midday sun, or is he the queen of the constitutional sky? And all this was answered equally picturesquely by saying, it is not the Potomac but the Thames that fertilizes the Yamuna, to use riverine imagery. Now all this ultimately only boils down to this, that we have chosen the Westminster model, and in the Westminster model, thanks to 1,000 years of British constitutional law, with the monarch's powers increasingly being decreased in favor of Parliament, the monarch ultimately is only a persuasive force and is not a parallel center of power. So the question directly arose again, and this time the court had a good look at the articles that were mentioned before. 74 and its counterpart 163 so far as governors are concerned. And these articles have to be viewed in the backdrop of 4 other articles. 77 and 166, which basically say that all executive power that has been vested in the President and or the governors, depending on whether it's the Union or the states, all such executive orders must be put in the name of the President or the governor. But when it comes to suing either the Union or the states, it is not the President or the governor who sue. Suing either the Union or the states under Article 300 is the Government of India or the state concerned. And consequently, under Article 361, therefore, for everything that is part of their function, the President's function or the Governor's function, under the Constitution, they are wholly immune from being sued. Now, looking at all this, and then construing Articles 74 and 163, the conclusion then becomes obvious. The conclusion then is that so far as the President is concerned and his counterpart, the Governor, is concerned, they are to act only on the aid and advice of the Cabinet, either of the centre or of the state concerned. An important change was made in Article 74 post-subsidy. The 42nd Amendment in 1976 added what was implicit in the article, that once this advice is given, the President is bound by it. The same was not added in 163, but the same would endure given subject for subject 6 judgment. Also then what was added was by the 44th Amendment, a couple of years later, saying that the President had this limited window of not agreeing with a cabinet decision and then voicing his opinion, which opinion would then have to be looked at. But once it's looked at and the cabinet then re-decides, the President is bound. So, when we see 74 and we see 163, we have parliamentary democracy as we know it, which is that at least so far as the President is concerned, in every sphere of activity and power, he is bound hand and foot by what the cabinet says. However, Justice Krishna went on to delineate 3 areas where he would be bound, but at the same time would have some limited discretion. The first area would be where the president was to appoint a prime minister. This would be conditioned by the fact that the prime minister would have to be the leader who is elected by his party to lead the party, and conditioned by the fact that that party had a majority in the Lok Sabha. The second discretionary power, so to speak, was to dismiss a government which had lost majority. Here again it is conditioned by the fact that it would clearly not have to have a majority on the floor of the House, and therefore be conditioned by and large by a floor test that would have to be taken. And the third would be a dissolution of parliament altogether to face the nation in another election. And here again Justice Krishna was very careful to point out, it is better he does not descend to party politics, but be guided even in this endeavor by the learned Prime Minister. So we see ultimately that so far as the president is concerned, is almost completely bound hand and foot. So far as the governor is concerned, on the other hand, the language of Article 163 itself tells us that there are certain discretionary powers which he may be required, the word is very important, required to exercise, either by or under the Constitution. So we have to actually see the Constitution in order to ascertain for ourselves whether by or under it. The governor here acts on his own, and if necessary, contrary to what his cabinet tells him. Also, under 163(2), to shore up this, a very important power is given to the governor to be the final arbiter of what actually is within his discretion and what is not. And once he decides something is in his discretion, he is the final authority to say, it's in my discretion and nobody can challenge. Now, this article again has to be read with certain other articles of the Constitution to find out what these discretionary powers are. The first discretionary power that you will get is with the state of Nagaland, under Article 371 capital A. And then there are 4 specific powers, where the governor is specifically to act in his own discretion. Those words are used. In the first, if an internal emergency is to be imposed in the state of Nagaland, it's the governor who is to do it, but after consulting the cabinet. He may go against what the cabinet says. Second, if he is to make rules for regional councils, he is to do so himself. And third, so far as a large district is concerned, Tuanzan, what would be the actual distribution of central finances between that district and other districts would be for the governor to decide. And all other matters with Tuanzan and other districts would be for the governor to decide. So there are these 4 clear demarcated areas where the governor acts entirely on his own. Also under the 6th schedule were 4 states. There is Assam, Meghalaya, Mizoram and Tripura. Under para 9(2), what is the share of royalties that come from mining, which is to be distributed between the state and district councils, is again entirely for the governor to decide. Apart from this, there are also certain other provisions. There is one interesting provision where there are quasi-judicial functions also given to the governor, where if a disqualification of an MLA takes place under Article 191, then the governor is to decide, but here again it is conditioned by his having to decide only in accord with what the election commission says. Then under Article 356 you have a very important power, and this is the power where the governor is the vital link between the centre and the states. The governor may opine that a particular state is not able to carry out its government by constitutional means and may therefore send a report to the president, telling the president that this is so and that therefore the government of that state should be dismissed. Now, all these are powers which the governor necessarily exercises on his own. Are there any other powers which are, let us say, hidden in some provision of the Constitution? That came up for discussion in 2004 in the MP Special Police Establishment case. And there the question was that 2 ministers of a particular state cabinet had to be prosecuted under the Prevention of Corruption Act. And sanction had to be taken for that prosecution. Obviously, the cabinet would not grant such sanction and did not grant such sanction. The governor acted on his own and said, yes, there is a prima facie case made out, I will therefore grant sanction. The governor's action was upheld, mind you, by the Supreme Court. And they said that this is an obvious case of bias, where a cabinet cannot decide in its own favor. And if it cannot decide in its own favor, this is one other small area that must be carved out under the Constitution for the governor to exercise his discretionary powers. Also then came up the governor being the final arbiter under 163(2) of what ultimately the function is and whether it's in his discretion. And this came up before the court in Nabam Rebia's case in 2016. Now, Nabam Rebia was a case which came up from Arunachal Pradesh. And there, the governor preponed a particular meeting of the Legislative Assembly by almost a month. And also said that the first agenda item in that assembly will be removal of Speaker. Question was whether he could have done this on his own without the cabinet approval. The Supreme Court emphatically said no. Then what was argued was, in any case, he determined that he could do so and that was final under Article 163(2). Again the Supreme Court said no, that finality can never attach when, as a matter of fact, when the court looks into whether he has such a discretion or he doesn't. He does not have such a discretion. So in short, when he acts outside his jurisdiction, Article 163(2) will certainly not come into play. So that's another very, very important advance that the court made. You see, at each stage, the court has been making advances and actually seeing that the spirit of the Constitution gets established every single time. Now, having dealt with these cases, we move on to another very, very interesting and very interesting area. And that area is that you can also have, and the governor also has, legislative powers. As you have seen, first and foremost under Article 168, the governor alone, along with the Legislative Assembly of the state and maybe a legislative council is there as well, forms the legislature of the state. He has the right, like the president, to address a special message, to receive messages, to give messages, to speak in the House, and above all has the right first to summon the House, to prorogue the House and to dissolve the House. Now all these powers are given under Articles 174, 175, 176. But the most important power is that of assenting to bills. And that you will find in Articles 200 and 201 of the Constitution. Now, under Article 200, unlike its counterpart with the President, there are 3 options given to the governor. 1, he may assent. 2, he may withhold assent, and in withholding assent, he may also send a message back stating that the bill ought to be amended in some particular. And 3rd, and this is what is very interesting, he may also refer the bill to the President for consideration. And if the 3rd option is followed, then we come to Article 201. And under 201, what the President has to do is then either assent to the bill and send it back, or say he is withholding asset, and ask the governor to send the bill back with either a message or no message saying that no, the bill can't pass or it can pass only in certain particulars. And if finally the Legislative Assembly of the state sends it back to the president, then the president has the last word and the president can actually kill the bill under 201. Now, very interesting questions arose before a recent judgment of the Supreme Court, particularly create timelines that could be involved in all the functions under 200 and 201. By the way, 200 lays down only one timeline, though there are many functions involved. And that one timeline is not a timeline at all. It only says that when a governor is withholding assent to a bill, he must send it back to the Legislative Assembly as soon as possible. Now, as soon as possible is not a certain period. It's an amorphous phrase. But when you come to 201, and the Legislative Assembly sends back something to the President, it must do so within 6 months. These are the only timelines that are there in 200 and 201. A recent judgment of a division bench was faced with 10 bills that had all been sent back. As a matter of fact, every single one of those bills was sent back, and ultimately the Legislative Assembly then sent it back to the governor. And the only option to the governor was then to accept. Now, instead of accepting, there was a wholesale reference only to the president. All 10 bills were sent to the president. As a result of which, the entire electoral mandate of the state got blocked. The Supreme Court came down very hard on this. And the Supreme Court said that, look, obviously, the three options given are three options. You can't exercise one of those options after you exhausted another. And it would be contrary to the plain language of the article as well. Because when something is sent back, then there is no veto power. The governor has to accept, finally. And this is only unlike the position of the president in the United States. Because under Article 1, Section 7, the president has a very real veto power over legislation. So what he can do is to send an act of Congress back. And that act can only be passed if ultimately it is passed with a 3/4 majority and not the 1/2 that is prescribed. There is no such thing here. So to get over this veto, an ingenious thing was thought of by the governor of Tamil Nadu. And our bank, all 10 were referred directly to the president. Now, in deciding whether there should be timelines, the Supreme Court first said that there is no option for, this is very, very important to remember, under Article 200. There are three options. There is no fourth option for a governor or a president under 201 to sit on the bill. And if you merely wait out the bill, you would be thwarting the entire legislative exercise that was done by the elected representatives of the state. That, coupled with the fact that every action has to be performed within a reasonable time, would necessarily entail the laying down of certain time limits. And then the Supreme Court decided in its wisdom to lay down different time limits of 1 month, 3 months, depending. Also, what was very important and what was decided by the court was that the governor did not have a discretion under Article 200 as to any one of the three courses that he may take. He is conditioned entirely by the aid and advice given by the cabinet. So if the cabinet were to say assent to the bill, he has to assent to the bill. If the cabinet were to say do not assent but withhold assent on ground X, he can only send it back on ground X and not on ground Y. This again was a very important advance made in the law, because up till then, B.K. Pavitra's judgment in 2019 had decided the exact opposite. Pavitra had decided that the three discretions to be exercised by the governor were personal to him and were not conditioned by cabinet approval. That was said to be contrary to Samsher Singh's judgment correctly. Also, it said that finally when the bill lands up at the ken of the president, and the president may ultimately decide to kill it, that judicial killing is not something judicially reviewable. That again the court said is not correct. So some very important advances were made in this judgment. Now, as we are speaking today, there is a presidential reference which is ongoing before the Supreme Court. And many of the questions I have alluded to are things that have come up in that reference. Nobody knows how they will decide. But of course, only one thing is clear, that it is obvious that a governor and or a president cannot sit indefinitely on a bill in order to be completely defeat. So, whether the court says that there is a fixed time limit, or whether it says it must be done within a reasonable time, and the reasonable time would approximate to ordinarily X, it could say anything. The important point is that once the time limit is crossed, it would be within the ken of a writ court then to say that we issue a writ in the nature of mandamus to say that since you have not said something within the time limit given to you, you have nothing to say. And since you have nothing to say, therefore, please, you, if you are the governor, assent to the bill by signing. And if you are the president, obviously you have nothing to say, therefore, again the governor has to assent to the bill, notwithstanding that it was sent to the president. Now, there are other conundrums which occur as to when something can be and cannot be said by the president. I have already told you there is at least one view, recent view of two judges of this court, which has said that you can only send a bill for reference to the president if the cabinet says so. But there are situations in the constitution which the court itself outlined, are situations where a governor may act contrary to cabinet advice. Now those situations are in several articles. The first article is 200, second proviso itself. Because in contrast to 200 and the first proviso, the second proviso says that a governor shall not assent to a bill if he, in his opinion, the words used are in his opinion, comes to a conclusion that something is being done detrimental to the High Court of that particular state. So, there is a direct constitutional provision which enables the governor to act contrary to what his Council of Ministers may tell him in 200 second proviso. Similarly, you may have several articles in the Constitution which require presidential assent. Now, 31A, all of you are familiar with, is the agrarian reform provision. It came up with the very first amendment to the Constitution. And if agrarian reform is something that a legislature of a state wishes to undertake, and it wants Articles 14 and 19 out of harm's way, then that can only happen if presidential assent is obtained under 31. Now that may be a situation where an agrarian reform legislation may require such presidential assent, in which case it has to be sent to the president again by the government. 31C is a second provision of this nature, which came up in 1971. Now 31C speaks of certain directive principles of state policy, 39B and C, and a law being made in pursuance of them. Suppose a law is made saying that the material resources of the community, for example, are to be so distributed as well as to serve the common good. And these are the material resources. And therefore, says this law is being made in pursuance of Article 39 small b. Again, we have to obtain presidential assent. That could be another situation. Then there are some other situations where, for example, under 288, suppose there's some interstate river, that project, river valley project that is involved. And the state wishes to levy certain taxes on electricity and water with that project. Again, that can't pass muster unless you have presidential assent first. You may also have the case of a financial emergency under Article 360, where the center, after declaring an emergency in that state, may also direct that no money bill can be passed without the assent of the president. Now, these are all specific situations in which a governor is actually tied down by or under the constitution. And he would be failing in his constitutional duty if he were to follow what the cabinet says. It's necessary, if it's necessary for him to go against what the cabinet said, he must do so. So, we have now seen that governors have powers which are beyond the president, and therefore they perform some very, very important functions which even presidents can't perform. And yet, we've seen they can be appointed by the center at will. Now, I would firmly wish that certain constitutional conventions could be laid down by a party in power. And this can only happen if a party in opposition becomes a party in power, and then vice versa. It can't happen if what is happening today since 2014. So if another party comes to the center which is an opposition party today, maybe it can lay down at a constitutional convention. Please look at the governor's oath. What does he have to do? He has to abide by the constitution, he has to look after the welfare of the people. Now, in doing so, obviously you can't appoint a person who's going to violate his oath immediately. You can't appoint a politician who belongs to your party, for example. So, establish a healthy convention saying no such person can be appointed to start with. Then you can also establish a healthy convention by what happens if the case is an obverse case, like the case from the state of Tamil Nadu. What happens if a governor blatantly violates the constitution and instead of assenting to 10 bills, sends 10 bills en masse to the president? The court castigated the governor, despite which we don't see any removal. Now, is it possible for you, therefore, to petition a writ court to say that, look, if the man has violated the constitution, he cannot be somebody above the president. Because if a president violates the constitution, he is liable to be impeached. Here, this man blatantly violates the constitution and nothing happens to him. Surely he has to be removed. So either the court does it or you establish a convention saying that once a constitutional court like the High Court or Supreme Court castigates a governor, the center has to remove it. So once you have conventions like these which are built up over time, and like I said, this can happen only if there is a real two-party system in operation. So that the opposition who moves this today then makes this a proposition when it becomes a government. Also, you can always have persons who, according to you, are worthy of being head of state. Now, there are certain minimum qualifications laid down. We've all seen that the relevant article says to become a governor, you need to be 35 years old and you need to be a citizen of India. Now, surely these are only minimum qualifications. So, by convention, you can add to these qualifications. And you can say, look, this is a man who has to fulfill the role of a head of state. Most importantly, he is not somebody who looks only to the center. Under his oath, he has to look only to the constitution and to the people of the state. He doesn't look at the center at all. But under certain provisions like 356 sometimes, he has to tell the center that there is something that is going on in the state which should not go on and which is unconstitutional. So, if healthy conventions can be laid down over course of time, just as the Supreme Court in Sigal's case made removal of a governor subject to a power not being misused, subject to the power not being used arbitrarily or mala-fide. Similarly, the power of appointment again with constitutional conventions building up can ultimately make this office a real office, where the man who is appointed governor first looks after and abides by the constitution and the welfare of the people of the state, and also acts as a go-between between the state and the city. Because ultimately we must remember, it is how a constitution is worked that is most important. If we find that a constitution is worked in a manner which is detrimental to the welfare of the people, then that constitution is not worth having. And if on the other hand we find that there are certain gaps in the constitution, as we find with the appointment of governors here, which are filled in the working by healthy constitutional conventions, then it's a constitution that we really wish to keep, and wish to keep, if not eternally, at least for future generations to come. Thank you all very much.
Thank you, Justice Nariman, for such an enriching lecture. I would now like to request our Honourable Registrar, Sir, to deliver the vote of thanks. Sir, will you be taking questions? Alright. So before the vote of thanks, of course, alright. Justice Nariman has agreed to take few questions. Very few. So 2, 3. So could we see a raise of hands? Okay, at the back. Yes.
Just come forward.
Can somebody please hand over the microphone?
Hello. Good evening, sir. Sir, my question was, when we had committees like Sarkaria Commission on the appointment of governors. So, as we seen that where there is discretion on the part of government to exercise their powers, especially in the context of assenting or withholding the bill or referring it to the president. So isn't it inevitable, and as we have seen, it is only in those states where the opposition party, contrary to the party which is in center, that this issue arises. So it is inevitable, no matter which party is in the center, when there is an opposition government in that particular state, the governor is bound to act in bias in the favor of the central government. So shouldn't we look to change the appointment procedure of governor itself? Like we have the appointment of CBI director consisting Chief Justice of India, Prime Minister and the leader of opposition. Can we have a committee like one representative from center, the Chief Minister of the state concerned and the Chief Justice of the High Court concerned, something like this?
Good question. Can you hear me? Can you hear me? Good question. According to me, all this would require constitutional amendment, which is very difficult. Rather than a constitutional amendment, something can be done by conventions. Fortunately, that's another source of constitutional law, which is why I mooted that perhaps healthy conventions could grow, if not in the near future, in the future, at some point of time. I don't see a constitutional amendment coming about in a hurry. But what the court can do is to refer repeatedly to the oath that a governor has to take, and to repeatedly emphasize that his allegiance is not to the center that appoints him, but to the constitution and to the people of that state.
Okay. Our Constitutional Law Society's faculty advisor has a question. So, can you please hand over the microphone here?
Thank you very much, sir, for that engaging lecture. I have a very small question. You spoke about creating a convention where the head of the state has to be of a certain pedigree. My question is, does a retired judge fall into that pedigree, sir?
Very good question again. Depends entirely on that retired judge.
Okay, one more question.
Yeah, the last one.
Okay, yes, second one.
And if I may add, that judge will leave a certain trail for you to judge. Whether by way of judgments or otherwise. Before I am due.
Hello. Sir, I am Rishit. I am in my 4th year undergraduate. My question is that ever since the arguments on the presidential reference began, a lot of people have been arguing that the Attorney General and the Solicitor General's arguments are aligning towards a particular idea in constitutional theory called executive constitutionalism, where it is the executive that sort of seeks to imbibe the spirit of the constitution. And they're arguing this by saying that by seeing or putting forth that the governor has the right to kill the bill because of the fact that the bill might have certain characteristics that might seem unconstitutional to him or them. So my question is, more than the governor itself, what do you think about this idea of executive constitutionalism, and is it really compatible with the structure of Indian constitutional democracy?
Good question. Executive constitutionalism has been decisively rejected by our Constituent Assembly. You have Article 145(3) of the Constitution of India, which specifically says that the last word on the interpretation of the Constitution is by 5 honorable judges of the Supreme Court.
Sir, just one question, sir. There is a controversy going on that governors are the ex officio chancellors of the state universities. What is your view on that? Should we continue with it, or is it something that we can discard?
That's not something you can discharge. Again, that's a matter for amendment because they are ex officio under statutes that are appointed. You can amend those statutes, but till you amend them, they are.
Thank you so much, sir. Will you be taking any more questions, or do we end it?
Again, 1 or 2 if somebody wants.
All right. So we take 1 or 2 more questions.
Okay, though.
Quickly. Okay, last. Yes.
Some lady wanted to say something there.
Yeah, you
Good evening, sir. Thank you for that enriching lecture. I am Shubham. I am the 3rd year.
Ladies first.
No, she is not having question. Yeah.
This is the lady concerned.
Alright, there's no lady concern. Go ahead.
So my question is on the maintainability of the presidential reference, the ongoing presidential reference. Sir, in the words of Article 143 of the Constitution, it reads that presidential references can be made to get the opinion of the Supreme Court. However, sir, the opinion of the Supreme Court has already been laid down in the judgment such that 3 months is the timeline that a governor has. So, sir, what is your opinion on the entire maintainability of the presidential reference?
My opinion is no opinion because it's not correct to comment on something that is sub judice.
Right. Please do ask questions which are not regarding any sub judice judgments. So, okay, last question. If any lady concerned tried to ask a question, can we please go there? Who was that?
Never mind anybody now.
Okay. All right. A last question, please. Okay. All right. Thank you. Thank you. So now I would like to request Professor Vijay Kumar to conclude.
After hearing Justice Nariman, I regret that I am not a sitting Vice Chancellor of a law school today. If I was, possibly I would have extended a request to make him a Professor of Constitutional Law at his law school, which I think the benefit can be reaped by the students better than anybody else. Sir, it was a wonderful presentation. And you must have seen he was not referring to any book or anything like that, right? He was just reeling out the judgment after judgment, so on and so forth. I would like to just recollect one anecdote. It is in the context of the oath undertaken by the President and the Governor, which is part and parcel of the text of the Constitution. They are not in the schedules, right? Whereas all other members, they take the oath under the schedule. And nobody takes the oath in the words that are presenting for the President and the Governor. It says to preserve, protect and defend the Constitution. Three important phrases. One of the governors, after retirement, he was appointed as the chairman of the Finance Commission. He came to the law school to understand the extent of the powers and functions of the Law Commission, and we were asked to make some presentation for half a day. After that, we were having lunch together. I asked him, I was sitting next to him, I asked, sir, you are a governor of a state. I don't even want to name the state because you can easily make the guess. Were you able to stand by the oath that you have taken? He looked at me, what do you mean? I said, preserve, protect and defend the Constitution. Again he looked at me and said, Professor, please read the phrase before that.